This
There we
meeting
go.
is being recorded.
Good evening, Kim. Thank you so much for joining us tonight. And we just introduced ourselves to you. We'd love to hear a little bit about yourself.
Sure. Absolutely. Well, thank you, first of all, for having me. I always love talking to special needs moms because I am one, and they're my favorite people in the whole world. One of my favorite things to see is watching somebody say no to a special needs mom and then watching what happens next, because it's just amazing how I know so many fantastic, amazing parents who have just risen to the occasion, and they're out there fighting and doing whatever they need to do to take care of their child. So I have a 17-year-old son. His name is Finn, and he has autism. And I have a 19-year-old daughter named Molly, who is in her second year of college. And she's studying psychology and disability studies because I think she's kind of a typical SIB.
Mm-hmm.
Her whole worldview has been shaped by her brother. And really, my son is the reason that I do the work that I'm doing now. So I started out many moons ago practicing law as a tax lawyer and loved it. But then I had Finn, and it rearranged everything in the world, including the way that I wanted to practice. So I kind of started over and reinvented myself. And so now I specialize in special needs law. I do special needs planning, which is a combination of conventional estate planning and benefits planning. I do guardianships, and I do consultation with divorce lawyers when there's a special needs child in the mix. And that's because sometimes child support payments, if they're not structured properly, can disqualify a child from SSI and Medicaid. So those are the three big things that are the huge majority of my practice. And I work with a lot of families that are just like mine. So it's a really nice way to spend my day. And I'm happy to be here tonight and to answer any questions that you have.
So tell us real briefly, and I know I asked you this on the phone as well, you also can practice in a few other states as well, correct?
Well, I'm about to be licensed to practice in Illinois. I think I'm maybe weeks away from that.
Okay.
That application is in process. I'm looking at getting licensed in Alabama, but I'm kind of at the beginning of that process. And Alabama seems to want you to live in Alabama if you practice there. And I do not live in Alabama, so I don't know how that's going to go. But I'm a partner at a national firm. It's kind of a national boutique estate planning firm. And so we have offices in a lot of different states, and they like for all of the attorneys to be licensed in at least 2 states as well. So if I needed to work with somebody in Florida or South Carolina or North Carolina or Tennessee or Illinois or Colorado or Missouri or a number of other states, I could do that in conjunction with one of my other partners.
Okay.
So I can cover a lot more ground now.
That's really helpful. That really is. So, I'm extremely practical. So some of these questions are very, very practical. The first one, what legal documents will our family members discover if we are best prepared for our passing?
Well, hopefully, the very first thing that they'll discover is a will. And I cannot tell you how many times we've had to probate something at my firm and discovered nobody knows where the original will is. So to be truly well prepared, you need to make sure that your family can find not just a copy of your will, but the original will, because it's more difficult to probate a copy. It can be done, but there's a lot more paperwork and it takes longer and it's more expensive if you're using a law firm. So hopefully the first thing they will find is your original signed will. If it's a draft, it doesn't count. It has to be signed and properly executed. So that requires a couple different signature pages under Georgia law. The will might be a big, long, beefy will that thoroughly disposes of all of your probate estate, or it might be this teeny little thing that's probably just a few pages long called a pour-over will. And if you have a pour-over will, then you would have that in conjunction with a revocable living trust. So the pour-over will just says, I leave everything to my trust. And then the trust really does the heavy lifting. The trust is really your estate plan.
Mhm.
So there are different, it depends on what assets you have and what your circumstances are as to whether a will or a revocable living trust would be most appropriate for you. But you'll either have one or both, depending on your circumstances. And then since all of us are special needs parents, I would hope that people will find a third-party special needs trust. So we have to distinguish between a third-party special needs trust and a first-party special needs trust. The third-party trust is the classic estate planning tool if you have a child who's on benefits. And it's called a third-party trust because it's designed to hold third-party assets. And that means assets that belong to anybody except your child. So there are two possibilities if you do have a third-party special needs trust. It might be a testamentary trust, which means it's built into your will. It's a section of your will, and your will says, I leave everything for this particular child to this special needs trust that I've created under article whatever of my will. That's not my favorite way to create a special needs trust, but it tends to be less expensive. The reason I'm not crazy about it is that you can't use that trust until you're gone, which means no one else can use it either. Your trust doesn't exist if it's a testamentary trust until you're dead. So the other possible way that you might have a third-party special needs trust is you might have what's called an inter vivos third-party special needs trust. And inter vivos means during life. So an inter vivos trust is a trust that's in effect when you sign it. It's not part of your will. It's a separate document that exists independently of your will. So then your will would say, I leave everything for this child to the blah, blah, blah special needs trust that was signed on this day. And one advantage to doing it that way is if you have other people in the family that want to make gifts for your child or leave assets to your child, they can also name that third-party special needs trust if it's an inter vivos trust, a trust that's created during life. So those are the big important things that someone hopefully will find.
So we're going to get back to the special needs trust, perhaps. I have a feeling that folks may have some questions on that. But if someone passes and there's no legal documents in place, what are the potential consequences?
Well, if you don't leave a written estate plan, then the state has an estate plan for you, and it's called intestacy. So the state law will say if you die intestate, meaning you die without a will, then every state is different. But in Georgia, what happens to your assets is if you are married and you have minor children, then your surviving spouse gets a third of the assets, and the remaining 2/3 would be divided among your children. Or if you have one child, then it goes 50-50 between the spouse and the child. If you're unmarried, everything goes to your descendants, so probably your surviving children. For a lot of people, that's what they would want anyway. Except that typically if you're married, you want everything to go to your surviving spouse. You don't necessarily want to divide your estate up into pieces and have your children get some part of it. And the really big problem with that outcome if we have a special needs child is if you pass assets through intestacy, then everybody just gets whatever they get outright. So there's no trust for them. So it could be disastrously bad if you die intestate and one of the people that's going to receive part of your estate is your special needs child, because that means you have left your special needs child a chunk of money that's hopefully more than $2,000. So they no longer pass the means test. So if a parent dies and the child is on SSI, then they will roll as a result of that parent's death from SSI to SSDI. And SSDI is not means tested. So in that respect, that's not such a total catastrophe. But the reason that that's really bad is we still care about the means test, even when our child is on SSDI. And that's largely because of the Medicaid waivers. So if your child is on, let's say, what we call a comp waiver in Georgia, that could be $70,000 a year that's paying for support for your child. And if they inherit money, unless we do something to fix that problem, they're going to fail the means test and they will lose their comp waiver.
Okay.
Sorry, I
Oh,
can't hear.
no. Yeah, no, I think there's just some background going
Oh.
on a little bit. Yeah.
Sorry about that.
So is there a difference, because I'm single and other folks on tonight are married? Are there different considerations for people who are married as opposed for people who are single? It just seems, one spouse will probably go before the other, right? Unless some accident occurs or something. What are the considerations, if any, in that situation?
Yeah, well, I mean, if you're married, then your priorities are going to be different and your estate plan is likely to have more layers to it. So I'm also single. So my estate plan is pretty straightforward. When I go, everything goes to my kids. End of story. I mean, I have trust set up for them,
Right.
but I don't have anybody in between me and my children that I want to
Right.
take care of. But if you're married, of course, typically you do want your surviving spouse to get some, if not all, of your estate. And that means you have to think differently about your planning, because you can't just say, the day I die, everything I have is going to be there to take care of my special needs child, because that's not going to be the case. So some people look at their assets and say, well, there are certain assets that I do want to go directly into my third-party special needs trust, even if my spouse survives me. Some people say, I'm leaving everything to the surviving spouse. I know that they're going to take care of my child while they're still here. And then at the end of that person's life, that's when we'll divide things up among the kids. So one issue that's a big deal in my practice is it matters a lot whether you're dealing with a married couple who have always been married to each other and they share the children, or if you're dealing with a couple who are maybe on a second marriage who have kids from marriage number one. So they don't necessarily share those children. They might want to treat all the kids as belonging to both of them. They might not. So that's something that I talk to people about a lot in my practice, because it affects the way that we're going to do their planning.
Sure. So if Kim, if cost is a concern, what are some options for families? And what if someone can't afford to set everything up just, right now, et cetera? What might they do?
Well, I mean, everything starts with the will. So if you're limited in what you can spend, I would say the absolute best thing you can do is have a good will that either has a testamentary special needs trust. So that costs less because it's one document, it's not two. Or you could even have a will that leaves assets for your child to a pooled trust. So a pooled trust works kind of like the way a mutual fund works. if you have a relatively small amount of money and you can't afford to necessarily have a corporate trustee someday taking care of your assets when everybody is gone, you can leave your assets for your special needs child to a pooled trust, and it will take those assets and put them in a big pile with everybody else's assets who's a member of the pool. And there will be one trustee that's managing all of those assets together as one big investment. And then the trustee allocates gains and losses proportionally out among all the members of the pool. And because there is one trustee that's getting paid from this big pot of money, all of the individual participants in the pooled trust get sort of an economy of scale. It's relatively inexpensive to have that pooled trust collecting fees.
Okay, and we'll come back to that too, because I'm sure I have more questions on that, or others might as well. If someone has had a will or other estate planning drawn up 10 or more years ago, is that okay? How often does someone need to revisit and revise?
It's a good idea to revisit your documents every maybe 2 to 3 years. So if it's been 10, I think it's absolutely time to take a look at your documents. I mean, you may have made plans for your kids because they were little and now they're not little anymore, and maybe they don't need a trust. Not your special needs child, but other kids. So, or, maybe some of the people that you've assigned some of the jobs to under your will have died, or you're not in touch with them anymore, or you don't like them anymore. So it's a really good idea to look at your will and make sure it still has provisions that are consistent with your wishes, and especially take a look at who you've assigned to do all the jobs, like executor and trustee, because those people may have changed.
So Rita is asking, how much is a small amount for a special needs trust? So Rita, do you mean a pooled trust? Do you mean what Kim was talking to about earlier?
Well, yeah, I guess partly. I mean, what's the small amount? So you want to do the pool. We actually do have a special needs trust, but we've been funding that by putting X amount away from every paycheck for the last 20 years. That's how we funded it. And when we're both dead, then there'll be some insurance money that goes into it.
Great. That's great. So as long as you have family members, like maybe other children or siblings of yours or nieces and nephews, or somebody who is willing to be the trustee of your private special needs trust after you're gone, then you can continue to have that administered for free. So the challenge comes when there's nobody who can do that in your family, either because they're just not qualified to do it, or everybody dies. And then you need a corporate trustee, like a bank. And typically a corporate trustee will not take a private trust that has less than about $1 million in it.
Yeah, it won't. No.
But that's, one of the things that I do when I'm drafting a private third-party trust, especially, is I have a provision that allows the trustee to pour the trust assets over into a pooled trust later. So if you've got, you're at your generation, and then you've got maybe siblings of your special needs child, so your other kids that you're looking at as potentially the next generation of trustees, and you're worried about what happens when those people are gone. Well, one thing I do is I always include a provision that allows a trustee to name a successor. So there may be unborn grandchildren out there, and 20 or 30 years from now, one of them might be a CPA or a lawyer, or, work in a bank, or have some other type of experience or knowledge that would make them a fantastic successor trustee. And just, we don't know who they are yet. We haven't met them. They may not even exist. But, if that circumstance arises, then somebody down the line, when you're gone, could name one of those grandchildren as a successor trustee. But there should also be a provision in your special needs trust that says the trustee can pour over into a pooled trust. So if by the time everybody is gone, but your special needs child is still around, if you've got less than the minimum that a corporate trustee is going to take, then the last trustee that's a person can pour over into a pooled trust, and they'll take virtually any amount of money. They'll take a trust that has $50,000 in it or less, and they'll just charge an annual fee that's relatively low. I just saw one that charges an annual fee of $750 to administer the trust.
So can we talk?
You're not going to find a bank that will do it for that.
So, okay. So if we have under $1 million, somewhere, whatever the, amount is, can we dive a little bit deeper into how a pooled trust works? Because I know we have 2 in Georgia, right? And there are other options in other states as well. We have the one that comes to mind, and I can send it to folks if they would like me to, is Bobby Dodd. BDI has one. The ARC has one. Someone recommended one in, I think, in Florida. So I've got a few that I can send out to folks to take a look at. How does that work? So say someone has a life insurance policy of $100,000 and it's just directed to that pooled trust. It's the costs are low, right? As you mentioned, but how is money distributed? What does that look like? What if someone needs, I don't know, dentures or something, some medical expense? How do they, again, I'm extremely practical. So how does it work?
Yeah. Well, the pooled trust has a trustee. You can't have a trust without a trustee. The trustee is sort of the human embodiment of the trust, because the trust is just paper. We need a person to actually take action on behalf of the trust. And that person is a trustee. But in the case of a pooled trust, that person is a trustee that has been put in place by the entity that is managing the pooled trust. So just like with any trust, there's going to be a human being who is administering the trust and keeping up with the trust beneficiary and making distributions and saying yes or no to requests. And the way that the money gets managed this is why I was comparing it to a mutual fund. If let's say I want to have a diversified portfolio of stocks, but I don't have enough money to go out into the stock market and buy a wide variety of stocks to give myself a diversified portfolio. So in order to get a piece of that diversified portfolio, I send my money to a mutual fund. They take my money and everybody else's money, and they put it all in a pot and they manage it, and they own this big array of stocks that I can't buy as a single person that doesn't have enough money. So by the same token, if let's say I have $100,000 to leave to take care of my child, and I don't have a family member that I trust to be my trustee when I'm gone, or maybe I have a generation of family members, but I don't know what's going to happen when those people aren't around anymore. I can't name a corporate trustee. They're not going to take it. They're not going to be able to justify the minimum fee that they would charge to take that trust. So I might join a pooled trust, or maybe just let my trustee do it later. And the way you join is there's a joinder agreement. So with a private trust, like I would draft for you, or another attorney would draft for you, that's a document where you get to make a lot of decisions. You get to say, I want these characteristics in my trust. I want my trustee to be able to do this. I don't want my trustee to be able to do this other thing. You can put in a lot of different provisions, and you have a lot of input when you're creating a private trust. The pooled trust is, here's the trust agreement, sign on the dotted line. The only decision you get to make is who gets the remaining assets when your child is gone.
Okay.
There's a sign here, kind of uniform trust agreement. It's one size fits all. And you've got one trustee that manages everybody's money. And when the trust investments make money, they allocate the gains out proportionally across everybody that's in the pool. If there's a loss, they allocate the losses out proportionally across everybody in the pool. So that trustee will do individual accountings to Medicaid. And of course, they make individual decisions with respect to every beneficiary. But as far as the management of the funds goes, everybody's money is in a big giant pot and it's all getting invested together. But that's why they were able to charge less.
Okay.
Because of the economies of scale. It's really one great big investment that you're just sort of joining.
So then would you, and as I look at it in terms of the future planning, the attorney is kind of the quarterback, right? They're the hub of all of this activity. So an attorney would reach out and give the families a few options of pooled trusts, if that's, or can families do a little bit of research on their own too?
Sure, either one. I mean,
Okay.
I know trustees who administer pooled trusts, and I do sometimes introduce my families to those people.
And so how does the distribution work? Is it a monthly? Is it, so, I mean, I keep thinking, is it like an ATM? You have an ATM card and you need, $500, or you need a dental appointment or something, so what does that look like?
It doesn't
Yeah.
have to be a monthly. I mean, it doesn't have to be any periodic amount of time. So,
Okay.
because we can't ask our child to time their needs to coincide with a monthly distribution. And no special needs trust should ever just give money to the beneficiary, because
Okay.
SSI considers that to be income. So we're not worried about income tax necessarily, but what we're worried about is we don't want our child to have income that offsets their benefits. So the way around that is many trustees use this thing called a TrueLink card. It's a debit card that you can load with money. So it doesn't work exactly like a conventional debit card, because the beneficiary can't go to an ATM machine and get cash, because that would be giving them cash. So we
Okay.
can't give them cash, but we can say to our beneficiary, assuming that they're capable of doing this safely and they're not going to get taken advantage of, we could say, here's your debit card. It's got $500 on it. That's what you're getting as spending money for the month. You can spend it on whatever you want. You can go to the grocery store. You can go to a movie. You can buy a pair of shoes. You can do whatever you want to do with it. When it's gone, it's gone. Now, that doesn't mean that there's no more money available to that beneficiary from the trust. It's a way to limit the potential losses that could happen if we put money into a beneficiary's hands.
Okay. Does anyone else have any questions specifically about pooled trust? So for your average family that has under $1 million or whatever the amount is a pooled trust something that you would recommend as a part of their planning, or is there another option
Not
here too?
necessarily. I mean,
No. Okay.
there's nothing wrong with pooled trusts, but I like the flexibility of a private trust.
Okay.
And as long as you've got people in the next generation that you trust to be your successor trustee, you don't have to worry about any of this stuff. So the only issue would be if you have nobody to act as your successor trustee, either you're going to have to find a corporate trustee or you're going to have a different plan.
Okay.
And a corporate trustee is not going to accept a trust that has less than $1 million in it.
Okay.
So if the trust drops below $1 million, say $1 million, I mean, they'll invest that. Do they invest a private? Do they try to keep the money up, or it's just?
I mean, they need to spend the money if they need to spend the money. It's there to take care of your child. So,
Okay.
Certainly the goal should not be, we want to keep $1 million in this trust. And, when the special needs child dies, we expect to have a balance of $1 million. That's not what the trust is for. But that's why I like the plan of creating a private trust and then having the option to pour over into a pooled trust.
Later, okay.
And as long as you have family members that you feel could manage the money, most of them, I mean, they're entitled to take a fee under Georgia law, unless you say that they can't, but generally they don't. I mean, I've been the trustee for family trusts because of what I do for a living, and I never charge a fee because I feel like that's my contribution to the family.
So what if we don't have anyone to act as an executor or trustee? You talked about some options. Are there any other options that we might consider?
Yeah, well, some entities like banks will serve as executor. So the executor operates under the will, and the executor's job is to take title to all the assets in the probate estate and then do whatever the will says to do with them. So they have a fairly short-term job. It's collect the assets, give them back out again, and then they're dismissed. So if you don't have a person who can serve as your executor, if you have enough money, you can name an entity like a bank. If you can't get a bank to accept that job because you don't have enough assets in your probate estate, the probate court can name an executor. So it would be a court appointed executor. So they'd get paid something. They'd be paid by the court. They would probably be paid a percentage of the estate. I think it's 1.5% of the estate.
And does that happen often where, people may need to have a court appointed executor?
Most of my families have people in the family who will do that job for them. So, it's a good idea to name as many people as you have. So it's okay to name a list of 4 or 5 people to be your executor. You shouldn't just name one unless that's all you have. I don't think I've ever worked on a probate matter where the court had to appoint an executor, but it can be done. I mean, if we don't have anybody, then the court will appoint somebody.
Okay. Moving on to guardianship. Is guardianship a necessity? And I know Rita Haggerty, you were had some questions too, so feel free to jump in. What are the pros and cons, and what if we feel guardianship is too restrictive? What are the alternatives?
Well, as far as that first question, is guardianship a necessity? It depends entirely on your child. I mean, if your child isn't capable of making or expressing decisions about their own care, then I think they should be under guardianship. If they're in danger of being taken advantage of by somebody who doesn't have their best interests at heart, a way to protect them legally is to have guardianship. If you're worried about being able to speak on their behalf and make medical decisions for them, they should be under guardianship. In some states, there's such a thing as a partial guardianship. Georgia is either you're under guardianship or you're not. So the way somebody mentioned supported decision-making, the way that I like to see supported decision-making used, assuming that guardianship is appropriate, and it's not appropriate for everybody, but if you feel that your child can't make safe decisions alone, or if you feel that they might be vulnerable to somebody who's kind of a predator, then to me, it makes sense to petition for guardianship and use supported decision-making to help you do your job as a guardian. So if you're a guardian, you have a list of statutory obligations that you have to meet. You can't just become somebody's guardian and say, okay, I'm the boss now. You're required under Georgia law to allow your child to participate to the extent that they can in decisions that concern them. And you should be listening to what they want and helping them to develop goals and work toward them. And I love the idea of having a team of people that can help your child with that. But that doesn't, the two things are not mutually exclusive. So you can have guardianship over your child and you can still do supported decision-making. The difference is that if the supported decision-making team says, okay, we've worked so hard to get towards this goal that you told us you wanted to reach, and here we are, and here are the steps we've outlined, and we've all got a plan. And the child says, yeah, I don't like that plan anymore. I'm going to go to Florida and live under a bridge. If he's not under guardianship, there's nothing you can do about it. So that makes me nervous. And it also worries me that there are people out there who will try to influence people like our kids. And if they're under guardianship, then they can't be bound by a contract. They can't legally marry. There are a lot of things that there are rights that are taken away, but those rights are taken away for the safety of the child.
So
So
you talked about the medical. Making those medical decisions if necessary. What about legal in terms of what if someone has interaction or something in the legal system and you do have guardianship or you don't have guardianship? Does that, that I think worst case scenarios, but I'm sure that does happen in some cases. Does that help to have guardianship in that case or not?
Yes. So one thing this is not true. And people say this to me all the time. So I'll just go ahead and dispel this myth right now. If you are the guardian of your child and the child commits a crime or gets arrested or gets into some kind of legal trouble, you are not responsible for the child's actions. So if your child, robs a store, you are not going to be arrested for that. So the guardian is not legally responsible for the child's crimes. But if your child does get arrested and have to appear in court, if you're a guardian, you have to be notified and you have a right to go to court and speak on your child's behalf. If you are not your child's guardian, you don't even have to be told that the child's been arrested. And I had one family come to me and just they had decided to pursue guardianship because their child was arrested and had a hearing in front of a judge. And there he is with his court-appointed attorney who can't understand anything that he's saying. And the parents went and stood up and said, Your Honor, we're his parents. And the judge is like, I don't care who you are. Sit down. And the judge would not let them speak at the hearing because they weren't his guardians and they didn't have a right to speak.
So they can't sign a contract so that nothing's legally binding. They can't marry. So marrying someone is taken away. What about voting?
Almost always the child retains the right to vote.
Okay.
I've only seen it taken away one time.
Okay. So does anyone have any questions on guardianship or supported decision-making? Yes, Rita.
Well, I want to revisit the medical part. We right now have we have in Nebraska, where I come from, it's called something different, but it's a power of attorney for financial stuff, but we have a medical power of attorney also. And it has a different name here. I'm sorry, I just can't think of it. So, so there's some decision-making as a group about medical stuff. Fortunately, she hasn't had any serious medical issues. So it hasn't been, she's never needed to have surgery. So, at this point, I know she could refuse. But on the other hand, we can help we can be in the room, we can be in part of the discussion about any medical stuff, and we always are. Somebody's there with her. So So I guess that's kind of nuanced to me,
Mhm.
especially on the medical side.
Well, you can be there unless she says that you can't.
Right. Well, she hasn't
So
done that yet.
and as long as she doesn't do that, then you're fine. But it's just if there's a guardianship in place, and I'm not saying that you should have guardianship. I mean, this is a decision for you to make. I don't know your child, and you do, and I really feel like, the person who cares the most in the world about that child is the one who should make decisions like this. So, I'm not here to tell you to petition or not petition for guardianship, but if you don't have guardianship, then your child can override your decisions.
What's the range of prices of getting a guardianship, creating guardianship?
Well, there are always filing fees. You typically you can do it yourself. I mean, and you can pay an attorney to do it if you don't want to figure it out yourself. But the filing fees in Georgia are usually somewhere around $700. So if you do it yourself, you're still going to have to pay the filing fees. And it's hard for me to give you a fee for what a lawyer would charge, because it just depends on the state you're in and the county within that state.
Lisa, did you want to say something?
Yeah, my husband and I are co-guardians. Can you express something that might happen because we're co-guardians instead of having one guardian? I know I've heard about, if we were in the emergency room, just one of us, that they might get on like a FaceTime, an iPad and get permission. But what are some things that might happen bad if one of us was not there? And
if
they
you're
did, something came up.
right. When you're co-guardians, the court expects you to act as two halves of a whole. In other words, you can't say, I'm going to be in charge of this thing and you be in charge of this other thing.
Oh, no.
You always have to act together. And
Yeah.
where that comes up the most often is in medical situations.
Medical setting. Okay.
So, and sometimes doctors are not lawyers. Sometimes they will just let you be there by yourself and they'll take care of your child because that's really what they want to do. But what they're supposed to do is if there are two guardians, then the two of you together have to consent to medical treatment. So they might say, we need to hear from both of you that you consent to this medical treatment.
And can that be done over, like over FaceTime on a phone, or do they typically have to be there in person? I mean, if she were in an accident and one of us was there.
The doctor, they would probably let you do it over FaceTime, but
okay.
It just depends on how much the hospital is worried about liability.
Just with her being 20 now, we're fixing to phase out of children's health care, and we've never had a problem there, but becoming more adult, leaving the children's umbrella, that might concern me at some point. Yeah.
Yeah, that you are legally, at least you're supposed to be there together to consent to medical treatment.
All right. Thank you so much.
But, sometimes doctors, especially as you said, if the doctor has known your child since she was 2, they're not going to argue with you. Even if you're not the guardian, sometimes they'll just let you make decisions because they know you. So it does get harder as the child gets older.
And they're getting new medical team. Yeah. Okay. Thank you.
Angela, did you put a comment in? Did you have a question about, it says children ? Was that you?
You're on mute.
Yeah. Okay, so my question was, if you have guardianship over your loved one, can they not have children? Because I know they have to have permission to be married, but I'm also...
Well, people have children without permission all the time.
Right. But I was just curious if that was in there, because I had read somewhere that they weren't, allowed to have children if you had guardianship. But that's why I'm here, is to
no.
find out exactly what's real and unreal.
Yeah, well, you can't, I mean, they have the legal right to have children. And if they are physically able to have children, then what are we going to do about it if they have them? I
Right.
mean, guardianship doesn't mean that you can't have children.
Mhm.
Sometimes it's an issue if people want to have, like, if they have a boy and they want to have them have a vasectomy.
Hmm.
Right.
If you are your child's guardian and you have a boy, you can't unilaterally decide that they're going to have a vasectomy, even if you're
Right.
the guardian.
Good. Okay.
Yes.
Thank
Yeah.
you.
So Kim, our covenant to you is 8:30. So I'm wondering if anyone has any other questions, because this time just flew by. Any other questions or?
I think
Okay.
it was
Okay.
great. It was
Okay.
a
Good.
great session. Yeah. Thank you so much.
Well, thank you for having me.
Well, Kim, I'm going to press the stop record here.